very good evening and a warm welcome to another episode of Law and Order. And today evening we want to bring to you knowledge about constitutional remedies in Sri Lanka with a particular emphasis on fundamental rights law and also writ jurisdiction in Sri Lanka. So to our Rupavahini studios here, we are happy to welcome Mr. M.U.M. Ali Sabri, President's Counsel.
Thank you.
He was a former Deputy President of the Bar Association of Sri Lanka and also the Treasurer of the Bar Association, and is known as a renowned lecturer and has been lecturing in many institutions including Sri Lanka Law College, and a former diplomat, and it's a pleasure to have you here, sir.
Thank you. Thank you for the invitation. Thank you.
So, sir, my first question is, first of all, what is a constitutional remedy?
Yeah, in the sense, if you look at the law on a broader sense, you call it as, there are few areas of law. The general civil law, like your land cases, your money recovery cases, and the general criminal law, which everyone knows now. Then, of course, there are constitutional remedies, which is primarily against the executive, against the government, against the administration. And you also have commercial law, which is arising out of business transaction. These are the four broad areas. There are many other areas. Constitutional law, as I explained to you earlier, and we say constitutional remedies, are remedies which the Constitution provides against the executive, generally against the state, for people who have been as a redress or as a remedy, if they have some sort of an issue, to find some solution. So that's been probably from the British law we have inherited. Now it has become a part of our Constitution itself.
And also now, sir, when focusing our attention on fundamental rights. Now, fundamental rights were introduced by the 1978 Constitution, which were enforceable rather than the fundamental rights which were there before. And we have a series of fundamental rights in our Constitution. Would you be able to elaborate on what these fundamental rights are, and why is it important that our Constitution gives protection to these fundamental rights?
So it's very, very important because this country belongs to everyone, the citizens and the human being altogether. So there is fundamental obligation on the part of the state to protect all the citizens. All citizens are generally considered as equal before law. Not only citizen, all are, I mean, if you look at 12.1, I'll come to that, even everyone in Sri Lanka under 12.1 should be treated equally, even though they may not be citizens. So fundamental rights are some set of rights which is fundamental, which has to be nurtured and protected by the state itself. So when somebody violates it, there is a remedy. So if I come to you, what you asked for is what is fundamental right. If you carefully look at the fundamental right chapter of our country, there is Article 10, 11, 12, 13, up to 17, the provisions relating to that, read with Article 126. What are the fundamental rights? The fundamental rights are, first, right to life, which is not given in the Constitution itself like in India, but our judgments have upheld. People have the right to life, that you can live with dignity. Then, of course, Article 10 is about your right for conscience. That means you can follow any religion of your choice, and without any restrictions, unless it is lawfully placed in. So that is called right of conscience. So that is one of your rights. Then, of course, Article 11 says no one can treat you or inhuman and cruel treatment cannot be made on you. Even the police or army or anybody for that matter, you should be treated with dignity. Article 12 is no one should be discriminated on the basis of your race, religion, caste, language, or your sex. So all are equal before law, unless there are limitations placed in terms of the law. Then, of course, we have Article 13. That means no one should be arrested or punished or curtailed of their liberty other than by way of the law established in the land. That's the norm of it. That is why we always say the presumption of innocence. Merely because somebody is charged doesn't mean or that will make him a criminal or convict. Until such time, he's just like anybody else. He's presumed as innocent. That is Article 13. Article 14 is very important. That is your right, like what you and me are doing. The freedom of expression. Of course, there are limitations. We have gone beyond that sometime. But limitation to say what you want to say, provided you don't malign somebody, you don't defame somebody, you don't create communal problems or disharmony among the people. So that subject to those limitations, the right to freedom of expression, right to engage in profession, trade, traveling, all those things. These are very, very important things. That's how we make our country a democracy, and a tangible democracy, and a vibrant and working democracy.
And also, sir, the 19th Amendment brought in a new fundamental right called the right to access information. Now, this is a new fundamental right which has not been, from the other fundamental rights have been there since 1978. So, in your view, introduction of the right to access information, how does it positively affect Sri Lankan citizens?
So that's very good because I think it's a progressive step. Progressive for the reason that government affairs should be done unless in exceptional circumstances there are certain limitations, more the national security and things like that, or national security, national economy, or sensitive information. The affairs of the government must be done in a very transparent manner. If somebody need that information, there should be a mechanism to provide that information. For example, even if you deal with a company or something, your company information, somebody third party wants to deal with you, you can go to the registrar of the company and ask for that information and check for yourself. So similarly, if the government is engaged in some sort of thing subject to certain limitation, you should be able to take it. So we are at the primary stage of it. It take little time for it to develop as a jurisdiction over a period of time, but it's definitely a positive step in the right direction. We should preserve that and allow it to progress.
And also, sir, now we all have this fundamental rights chapter and it's enshrined in the Constitution. In the event one of our viewers, or if a citizen or a person has his fundamental rights breached, or let's say for an example, if a person wants to express himself and the government restricts it, or if his right to information is denied, or if a person is tortured, how does one exercise the remedy he has?
Yeah, fundamental rights are against the executive and administrative action. So necessarily against a private action you cannot. If say these fundamental rights are available on basically on two things. One is your rights have been violated, or there is inaction on the part of it. For example, if some police illegally arrest you, you have a fundamental right against that illegal arrest. You can challenge that. I'll come to that. Similarly, you have been mercilessly assaulted by somebody, but police is not taking action. So asking them to take action also, there is a fundamental right. So fundamental right, jurisdiction as an actionable wrong, executable remedy was brought in by the 1978 Constitution. So in terms of that, we must understand it has to be violation on the part of the executive or administrative action. That is number one. Number two is you must go to courts within 1 month of the alleged incident of the violation of the fundamental right. Or sometime you can, if you foresee a fundamental right violation, you don't need to wait till that actually take place. You can go to courts on the imminent infringement of fundamental rights. So that is it going to take place, and before that I want this one. So it has to be executive administrative action within 1 month, or before fundamental right actually been breached, you go to court, and you go to court to the Supreme Court. That's how Sri Lankan. So you straight away go to the Supreme Court, and in terms of the Constitution, Supreme Court should deal with it within a period of 2 months' time. It's a constitutional provision. Whether it's been done or not is a different thing, but those are the constitutional provisions which related to fundamental right. So if there is a violation, you could go to the Supreme Court and seek a necessary remedy depending on the kind of violation you are talking of.
And now, sir, when we talk about the 1 month period, it has been criticized by certain academics and also human rights activists and also members of the legal profession as being inadequate. What is your response to that allegation?
Yeah, but then courts have kind of, in a suitable case, courts have found and given exceptions also, but 1 month had been there. I don't know fundamental right, merely because of you don't have a fundamental rights application or the time period lapses on 1 month, you have other remedies also. Civil, this is in addition to the civil remedies and other writ remedies and all. So there are arguments for and against this particular 1 month period. But imminent infringement you can go. Otherwise, you say sometime before that 1 month is lapsed, you can even go to the Human Rights Commission and ask them to inquire into, and if they don't, after inquiry, if they found that your fundamental rights are violated or inquiry is over, that period during which the case is pending in the Human Rights Commission, the time period will not run. And sometime courts have held, if somebody had been arrested or kept in custody or prevented the causes beyond his control of coming to courts, then they have relaxed it and allowed that from the date of release or something to come for 1 month. So it's a continuous argument for and against it is there. So it's an extremely limited period. Unfortunately, when court very strictly adhere to 1 month period to reject an application, but there is also subsequent provisions in the Constitution. Within 2 months, you must give the judgment on that. Hardly you see a judgment on 2 months' time unless something nationally important, some political case or something. So these problems are there.
And also, sir, now you mentioned about the Human Rights Commission. And in the event of a breach of a fundamental right, you could also file a complaint at the Human Rights Commission. Is this an alternative to a fundamental rights action, or how does filing a complaint at the Human Rights Commission work? And what powers does the Human Rights Commission have to maybe investigate or to give a remedy to this complaint?
So that's a lot of people when talk about Human Rights Commission, they say it is a toothless tiger. That is because it doesn't have the power to implement its decisions. But nevertheless, Human Rights Commission, with all their limitations, have done remarkable good job in helping certain people who are desperate. Because everyone or most of our citizens are not in a position or to afford a fundamental right application in the Supreme Court, which is generally costly. If you want, the documentation itself will cost. And in that kind of situation, people can go to the Human Rights Commission and do. So they probably try to go through the inquiry and give recommendation. But sometime, if it is the government or a government body in the public interest, I think they are morally obligated to carry out those recommendations unless there are good and sound reason not to do so. But unfortunately, that spirit has not been followed by most of the institutions, and they just don't care sometime. But some officers and some institutions, they do. So that's also work in progress. So the argument is, without that, what is the remedy? So it may not be very effective, but removing that will not be the right. So giving them, further empowering them probably will be the right way to do. But we also should, as citizens, must not misuse those opportunities also. So this problem is with that. Sometime when we give them, or sometime we have these rights, rather than we are looking at our responsibilities, we only go after the rights and misuse it and abuse it. As a result of which, the authorities also vary. For example, if every application for no reason, no good reason, bad reason, no reason is somebody going and asking you information about something in the government and all those things and abuse it for some reason, can be a problem practically implemented. So you should do it for right reason, not with extraneous purpose or some hidden agenda. So if you do that in the right spirit, I think when we progress over a period of time, when the economy develops and people tend to educate themselves and engage in different things and all those things, like many other jurisdictions, we will hopefully come to terms with it, and will be hopefully using it in the right spirit.
And also, sir, now when we talk about fundamental rights, we spoke about the remedies you have, that you have to file action within 1 month, and you can file action against any executive or administrative action. Now, there were certain changes to the fundamental rights law in Sri Lanka with the 19th Amendment. Would you be able to elaborate on what these changes are and how it affected the fundamental rights law in Sri Lanka?
No, then I mean, there were changes in the sense to challenge some of the acts of the president himself, when executive himself had been changed, and accordingly the argument now is, other than the right to call for the war and peace, everything else could be challenged in a Supreme Court, and somebody says no, there are certain areas you cannot. But generally it allowed to challenge the President's Act also in the Supreme Court by naming the Secretary to the President, no, AG, by naming the AG on behalf of the President. So I mean, it's a difficult thing for me to personally say, because there is always two aspects of it. One is, you should also be able, government of the day should be able to carry out its mandate and the policy of the government without undue restrictions and undue interferences. That's how a country could progress. But similarly, the government of the day and the executive should do it within their limitations. They must understand that constitutional limitation. So if you continue to interfere in the affairs of those things, and every action is challenged in the Supreme Court, then every tender is being challenged in the Supreme Court, the whole development process comes to a standstill. So it's a double-edged sword, carefully used. That's why it's important that as citizens in Sri Lanka, while we are very zealously guarding our rights and our privileges, we also must think of obligations and responsibilities. There is a separate chapter in the Constitution.
Exactly. So that's a very interesting thought, and in a lot of discussions and forums and in media, we talk about fundamental rights all the time, but less prominence has been given to the directive principles of state policy and fundamental duties. Would you be able to shed some light on what these fundamental duties are, and to what extent are they used in the Sri Lankan legal sphere?
Yeah, it's not used so much in that sense. Fundamental duties are just like you have fundamental right. There is a chapter of the Constitution itself, from Article 27 onwards, fundamental obligations and directive principles. So those are not enforceable, but it provides certain duties on the government as well as the citizens. So citizens also have certain duties. Nobody knows, but they know about their rights so much. So the ultimate expectation is that every citizen in this country will be conscious of his duties and obligations, just like his rights and privileges. So in that sense, you, me, and every one of us have certain duties toward the state. That's how countries have developed. So this is an area, I think, probably, I mean, we should include that into the syllabus of O-level students also, fundamental rights and fundamental obligations. So they know what it is expected. And that's an interesting area which we need to look at it and promote on the long run, yes.
And also, With that, I would like to end. We would like to end our discussion on fundamental rights, and there is also another popular remedy when it comes to administrative action, which is called the law of writs.
Yes.
So, in very simple terms, would you be able to explain to us, what is a writ, and on what situations can you file a writ?
Yeah, writ is basically the principle is simple. That is the certain powers which are being given on the government institution, quasi-judicial authorities are given in favor of them to exercise for and on behalf of the public on the basis of public trust and public interest. So, if you don't do it in that way, people should have a right or remedy against this. So, this is coming from a long period of time from English law. We have brought it into the Constitution now. There is separate provisions in the Constitution itself from Article 142 onwards. So, based on that, if a particular executive or administrative action has violated your rights or about to violate your rights or probably may violate your right on the long run, you have several kind of remedy. For example, if they have taken a wrong decision as a result of which your rights have been affected. For example, your properties have been acquired without following the due process. So, you should be able to go and challenge it, and that acquisition order could be on certain circumstances challenge. How do you do that? There is something called writ of certiorari, that is to go and quash that decision. So, if that is being quashed, there will be no decision. So, you are getting back to your original position. That is one remedy. Other one is, in the morning we argued another matter about, for example, your property had been acquired by the government on the basis of a public purpose. For 10 years or 15 years or some long period, it had not been used for the public purpose and given it to somebody else for a private purpose. Then, in terms of the law itself, if the property had been acquired, no compensation had been paid, you could always go back and ask the minister to divest it to you, give it back to you, because you have taken it for the government purpose and you are not giving it, and you are giving it to some other purpose. So, if the minister refused that, you can go to courts and ask to compel the minister to give you. So, that's a debatable thing whether you could do it. So, in that kind of situation, you go and ask the minister to divest it. That is called a writ of mandamus. That means you are compelling a person to do certain thing which he is legally bound to do. It has to be legally bound. Other one is, somebody is going to or about to take a decision which could violate your rights. You can't sit and wait. It's about to take place. So, you can go to the Court of Appeal or to the Provincial High Court for that matter and ask for writ of prohibition. That means prohibit that person from going along this wrong line and taking certain decision. And there are other remedies. For example, a quo warranto. Quo warranto is, show me the warrant to have this power with you. For example, when Mrs. Geeta Kumarasinghe was unseated, that was a quo warranto. So, they told that you are a dual citizen and you are prior to you becoming a member of the parliament, you have not given up your dual citizenship. So, that was a quo warranto. That is a public official asking a public official to show the warrant to continue his job. So, there are different remedies. Generally, Court of Appeal has the writ jurisdiction, but if it is a matter within the purview of the provincial thing, Provincial High Court has that jurisdiction. The difference is writ jurisdictions, the fundamental right jurisdictions are little more lenient and basically on the fundamental right chapter of it. But mostly now you can file fundamental rights and writ matters for many of the matters, because Article 12.1 had been interpreted to say if somebody does anything arbitrarily, you can challenge that by 12.1. So there is a very thin difference between writ jurisdiction and the fundamental right jurisdiction in some of the instances. There is no 1 month limitation in the writ jurisdiction. You have to go within a reasonable period of time. So it's an interesting thing. I think for the layman, what you should understand is that if there is your grievance is against the state, if your grievance is against the quasi-judiciary authorities, there are either remedy in the Court of Appeal and a remedy in the fundamental right.
Thank you, sir. And now with that, we conclude today's episode on law and order. And today our topic of discussion was constitutional remedies, particularly fundamental rights and writ jurisdiction. And on behalf of the administration of Sri Lanka Rupavahini Corporation, I would like to thank Mr. M.M. Ali Sabri, President's Counsel, for taking time off his busy schedule for being here and shedding light on these important aspects of law for the benefit of our viewers. So with that, we would like to conclude today and wish you all a good night.
Thank you.